if you've been following the Logan Paul / Coffeezilla defamation saga lately, you probably have heard that Logan Paul has recently been taking down videos talking about the case with privacy notices. Now, at first, like probably most people, I thought that this was just Logan Paul being vindictive. But now a recent filing showed up that explains, in my opinion, absolutely everything. And while it would probably feel very satisfying to everyone's inner petty billionaire to just say that Logan Paul is being unreasonable here, my job is to call balls and strikes as I see them, and to me, it looks like he actually has probably some good reason for these privacy notices. Now, that's not to say that anyone who got these privacy notices did anything wrong. Rather, I think that most people who comment on cases like this try to be careful where they think they need to. And so I wanted to make this video to highlight what happened, why people fell over this tripwire, and most importantly, how to avoid something like this in the future. Let's get into it. Okay, so as always, if you are new to this whole saga, there is a link in the description below to a playlist of videos that we've created here talking about absolutely everything from the very beginning so you can get totally caught up. But for those of you who have been following all of this, you probably have heard about the scummy text messages that came out that Logan Paul exchanged with some of his friends back and forth that came out in the defamation case that he filed against Coffeezilla. And so naturally, there are a lot of people who are very interested in hearing about this case, and particularly about something like those text messages. And so after we made a video on it, a bunch of other channels also started talking about it, some referencing this channel's video and some just going straight to the docket and pulling the filing and talking about it from there. And by the way, to everyone who did reference Legalbytes and linked back to our video on it, thank you very much. It's always great to see content creators supporting one another, and I'm really glad that other people found our content useful. Anyway, not long after that, people started getting privacy notices from YouTube.
So I got an email from YouTube the other night, and the video I uploaded on Logan got this complaint. Dear Kavos, we would like to inform you that we have received a privacy concern about your content. Before we review the content, we would like to give you an opportunity to review and, if necessary, modify or remove any potentially private information within the reported content. Receiving this notice does not imply a violation of the YouTube privacy guidelines, and no action has been taken against your content or channel at this time. Please find below the list of the reported content with the reported video timestamp. Please note that the violation may also occur other timestamps, as well as in the audio title, video description, channel image or background. Reported content and details, the video upload on Logan, and the timestamps were 7 minutes 52.
Okay, so I get this message, okay? I'll read this to you. Jesse on Fire, we would like to inform you that we have received a privacy concern about your content. Before we review your content, we would like to give you the opportunity to blah, 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 blah. Okay, so bottom line is, privacy concern filed against my channel, potential strike, potential removal of the content. And it says right here, the information reported as violating the policy is from timestamp 1652 to 1735 and 1801 to 1832. So that's a total of about 90 seconds. So we're just going to go ahead and watch which video that is, and specifically the timestamps, and then let's see if we can read between the lines of what this message is supposed to mean.
And that is always a concern, of course, especially if it's uncertain why that's happening. Sometimes privacy notices are legitimately necessary when someone is, just as an extreme example, maybe doxing another person or their family or something along those lines. But other times a person might try to issue a privacy notice just to make someone's life difficult. Or in other words, to try to get content taken down just because you don't like what people are saying. But the thing about that is if someone is improperly issuing privacy notices, the people who are getting their stuff taken down aren't doing anything wrong, and yet their businesses are getting messed with. Because let's be real, YouTube is entertainment, and for most people it's leisure, but for those who actually run channels, it's also a business. It's how people make their income. And so where someone is issuing improper privacy notices, these channels would have a potential claim for things like tortious interference with business relations. So basically what I'm saying is it's not a small thing for someone to be issuing privacy notices, and people should think carefully before issuing one. Of course, to someone like Logan Paul, getting sued by a handful of YouTube channels for something like tortious interference would be like small potatoes probably. He is, after all, a self-proclaimed petty billionaire. But anyway, after all of these privacy privacy notices were issued, Logan Paul filed an unopposed motion to partially seal defendant's motion to transfer and stay and exhibits D, E, F, G, H, and J. The motion is unopposed, which means Paul's legal team talked with Coffeezilla's legal team behind the scenes, and everyone agreed with this course of action. So unless Logan Paul's legal team is lying here, which I wouldn't expect them to be so blatantly dishonest, especially over something like this, we're not going to see Coffeezilla's side opposing this motion. Anyway, basically, the motion says that in Coffeezilla's motion to transfer venue, he attached some exhibits that had some sensitive information in them. And so they want to basically replace the motion and all of its exhibits with a new version that redacts the sensitive information. Specifically, we're talking about information related to those text messages. So it says, on April 15, 2025, defendants filed their motion to transfer and stay proceedings. Exhibits D, E, F, G, H, and J are all copies of text messages between plaintiff and others that plaintiff produced in discovery. Portions of those exhibits are also screenshotted and included in the body of the motion to transfer. The exhibits and the screenshotted portions thereof included in the motion contain plaintiff's private cell phone number unredacted. As a result of this disclosure by defendants, plaintiff, who is a public figure, has been inundated with harassing telephone calls and text messages from individuals who obtained his number from the public filing. Accordingly, good cause exists for plaintiff's phone number to be removed from the public docket. Plaintiff is submitting copies of the previously filed motion to transfer and its exhibits D through H and J that have been redacted to obscure plaintiff's telephone number. Plaintiff requests that the existing public versions of those documents be replaced by these versions so that plaintiff's personal cell phone number no longer appears on the public docket. And so now if you scroll down this document, you can see that they basically included this whole motion to transfer, but with all of the phone numbers redacted. And that makes perfect sense. If these documents have an active phone number that is still in use by anyone, whether that is one of the parties or even a third party, it is something that really should have been blocked out in the first place. So at this moment, let me take a step back really quick just to explain what's likely going on here. So as you know, there is a protective order that's in place in this case. And so during the discovery process, as the two sides are producing evidence to one another, there is bound to be information that is embarrassing, that is personal, and some that might even be sensitive. Information that is embarrassing or even damaging to one side isn't necessarily going to be able to be marked confidential to shield it from the public. And as I've said before, this is always a risk in any kind of litigation. However, information that is sensitive, things like social security numbers, personal phone numbers, addresses, personal email addresses, those are things that generally need to be kept confidential. And so the side that's producing this information might mark the documents as partially confidential or totally confidential. Or they might just hand it over to the other side with the expectation that the other side will handle it properly. Keep in mind, not every single civil lawsuit will have a protective order in place. And that's because they're not always necessary. Both sides are already under an obligation to ensure that any kind of sensitive information that they get their hands on during the discovery process is going to be kept confidential. In fact, there's a whole array of rules that govern all lawyers and law firms that make sure of this. And that includes the rules of professional responsibility, which can impact a lawyer's license to practice law. So information that actually is sensitive doesn't necessarily need to be marked confidential in order for the lawyer or the law firm handling it to have that obligation to keep it private. So now looking back at this whole subject, my estimation is probably that this is what happened. Logan Paul handed over all these text messages to Coffeezilla in discovery. And these text messages were probably with like a whole mountain of evidence that got produced at the same time. It's not uncommon for litigation discovery to have basically these massive info dumps that all happen all at once. And so it could very well be that Paul's side didn't flag that there was sensitive information in there, namely these phone numbers, because they were just like, well, Coffeezilla's side will know that they need to be careful with this. They have that obligation and they know that they have that obligation. And then when filing the motion to transfer, Coffeezilla's side attached the text messages as exhibits after painstakingly redacting all of the other information from the motion and from the other exhibits. And people can ask all day if Coffeezilla's side maybe intended to sort of leak these phone numbers in this filing. Personally, I don't think so. There's just too much pressure on any attorney that is litigating any case that involves any amount of sensitive or confidential information for that to be the case. And so I don't know of any attorney that would be willing to put their law license and therefore their whole legal career at risk for something like that. So my guess is that after going over the motion again and again and again and checking for anything and everything that even references any information that falls under the protective order, of which there is a lot in this particular motion, by the way, someone probably just forgot to double check these text messages. Honestly, as I'm imagining it, I feel secondhand anxiety over this screw up because, to be completely honest, this is a screw up. And it's the kind of screw up that when I've been in these shoes with the pressure of handling confidential information would take years off my life with the stress. It's one of the reasons why being a litigator is probably one of the most stressful jobs out there. You have to move quickly. You have to move precisely. You have to make the best possible arguments that you can by turning on a dime sometimes, and you have a volume of cases all at once, and you have to be as perfect as possible when it comes to confidential information. And at the end of the day, improper disclosures, they happen. They suck, but they do happen from time to time. And if you've been following this channel for a while, you probably know that the Rust film set trial happened a year ago, where the armorer Hannah Gutierrez-Reed was on trial for the death of cinematographer Helena Hutchins. And you might also recognize that this was the same kind of thing that happened with another disclosure in the middle of that trial. They threw up the defendant's text messages that were exchanged with some other people while she was working on production, and the prosecution failed to redact the phone numbers before doing so. So in the middle of trial, the defendant started getting all kinds of horrible text messages. So, like I said, these things, you never want them to happen, but occasionally they do. Anyway, so this brings me to how this impacts people like us, people who are talking about and sharing these documents that they get from a public docket like this. And more importantly, how to avoid certain tripwires that can come with them. Now, first off, it is totally reasonable for anyone to assume that if they are getting something off a public docket, that it must be okay to share. After all, it's a public docket. It's not like people are trying to get behind closed doors to get this information. It's just there for the public to freely access. And it's also reasonable to expect that if there was information that was confidential, the legal teams on both sides are going to make sure that the confidential information is scrubbed before it gets released to the public. I mean, for example, if we look at this case with these text messages, for all anyone knows, these phone numbers are no longer active or owned by any of these individuals anymore. The public just wouldn't have any way of knowing that until suddenly it becomes a problem. However, keep in mind, like I just said a minute ago, mistakes do happen. And that seems to be what happened in this case. Someone probably missed a detail that they were supposed to redact, probably because their brain just got tired from hunting down every little detail that they needed to find. And so something slipped by. And something that we would probably all do well to remember is that just because something got improperly disclosed to the public already doesn't necessarily mean that it's no longer confidential. And so when we're accessing these public documents, it's worthwhile to take a pause and double check to see if anything that we're looking at might be something that we're not supposed to see. For example, I have seen whole documents filed on a docket publicly there, ready for anyone to see, that were actually marked confidential. That's a pretty big red flag. And after seeing that, I could have said, well, hey, it's on a public docket, so anyone could see it anyway. I might as well share it. But especially as a lawyer, I know better than that. If it's marked confidential, it's always worth erring on the safe side. And so while looking at this, I remember thinking, I'm not supposed to be seeing this probably. So I clicked the box to close it out and basically pretended that I didn't see anything. That's probably what's required of me as an attorney, regardless of whether I'm litigating the case or commenting on it. And now the vast majority of people who are talking about this case and other similar cases that are very spicy, very dramatic and whatnot are probably not attorneys like me. That said, YouTube has also made it very clear that they will put a similar burden on anyone that is sharing information on this platform. And now, personally, this is probably the second time now that I've seen phone numbers get disclosed in text messages that are produced as evidence, and then it turns out that those numbers are very much active and were supposed to be redacted. And so personally, whereas my assumption before would have been that these numbers were probably no longer active, the attorneys are all on top of it, they would have redacted everything that needed to be redacted, just to err on the safe side so that my own videos don't get taken down and I don't have anybody leveling any kind of accusations at me personally that could impact my licensing, I'm going to assume the exact opposite. If I happen to see something that's in an exhibit or is referencing evidence where there is a number that looks like a phone number, I'm going to assume that someone messed up and didn't redact something that they should have. And so my general recommendation to anyone that is covering cases like this is this. Anytime there is something attached to a filing that looks like it has information that is the kind of information that anyone would reasonably be able to tell was probably private, social security numbers, phone numbers, personal addresses, personal emails, things like that, I try to remember to take a beat to figure out whether this is something that should have been redacted. Because if it should have been redacted, then it was a mistake for it not to have been. And if that's the case, there is a chance that YouTube could take down your video if you don't blur it out or obscure it somehow. Obviously, if this kind of thing can be missed by the legal teams who are paid in part to ensure that stuff like this is kept secret, it is entirely reasonable for anyone in the public to also miss it. That's especially in situations like this, where the information that's sensitive is like needled in with other numbers and characters, and people might not even be familiar with recognizing what it is that they're even looking at. But given the consequences of the kinds of things that can happen when this kind of information does get out and does get shared, YouTube is going to try to minimize their responsibility, and doing so by getting these videos taken down when asked. And in a similar vein, YouTubers are already at this point basically used to dealing with issues related to, for example, copyright claims when people are using other people's material. And so basically what I'm trying to say is we can probably avoid about 90% or more of these kinds of privacy takedowns by taking a beat when we are looking at documents like this, even though they're coming from a public docket, just to double check to see, is this information that was supposed to be kept private? Is this the kind of information that anyone can reasonably kind of figure out, maybe should have, and then erring on the safe side? But those are my thoughts. What do you think? It does suck that people had their videos taken down over this whole thing, but after having seen the filing and what exactly the issue was, what are your thoughts on all of it? Do you think that it's reasonable for these privacy notices to have gone out? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.